you know, um, you usually expect a competition to have like a real sense of finality to it.
Right, absolutely. We crave that kind of closure.
Yeah. Think about uh, running a marathon, right?
Yeah,
You cross the finish line, the clock stops, the official hands you a medal, and you go home.
exactly. The event is definitively over. Done or not done, the outcome is clean.
Right. But I mean, the legal system doesn't automatically operate like a simple foot race.
It definitely does not.
The finish line can seem, well, incredibly slippery. Like you might win a trial and the next day you find out the other side filed an appeal.
Or they filed a brand new lawsuit in a completely different state.
Yeah, exactly. Or they altered their legal theory just slightly, to take another swing at you. It can feel like this never-ending loop, just a literal nightmare of permanent litigation.
And without a strict set of architectural rules to stop it, the legal system would absolutely be a machine of endless litigation.
It would just break.
Completely. The courts would collapse under the weight of people demanding rematches.
So, welcome to this custom-tailored deep dive. We are
Yeah.
speaking directly to you, our listener.
Yes, welcome.
We know you are staring down the barrel of a monster topic for the multi-state bar examination, the MBE.
It's a huge one.
Today, our mission is to completely conquer the rules that stop endless litigation. We're talking about the preclusion doctrine.
It is an expansive topic, heavily tested and notoriously full of traps.
Oh, yeah.
The examiners love to use it to confuse you, but underneath the dense vocabulary, it is actually an incredibly logical system.
And we're going to make a promise to you right now, because legal textbooks are notorious for dense jargon and like ancient Latin phrases.
So much Latin.
Right. And it does nothing but create a barrier to entry.
Yeah.
So we are throwing that barrier out. We are going to translate every complicated Latin term into simple, everyday English.
Which is so important.
Exactly. If English is your second language, or if you just happen to despise confusing legal speak, you are in the right place. We are going to rely on visual mind maps and easy mnemonics so these rules permanently stick in your brain for exam day.
Memory relies entirely on structure. I mean, we really should build that structure before we dive into the microscopic details.
Let's do it. Paint a picture for us.
Okay, so visualize a giant, sturdy oak tree.
A giant tree, got it.
The thick trunk of this tree represents the preclusion doctrine itself. In the simplest possible terms, the preclusion doctrine is the master rule preventing people from suing over the exact same dispute multiple times.
Okay, the trunk is the master rule.
Right. Now, from that main trunk, the tree splits into two massive branches.
Okay, so the first branch is claim preclusion. And the old Latin term you will inevitably see in your case books is res judicata.
Yes, res judicata.
Well, we are just going to call it claim preclusion because it tells you exactly what it does. It precludes a claim.
It's so much simpler. And the second branch is issue preclusion. The Latin term for this one is collateral estoppel. But again, issue preclusion is much clearer.
Right. So visualize your tree. The trunk stops repeat lawsuits. Branch 1 is claim preclusion. Branch 2 is issue preclusion.
Exactly.
But before climbing out onto those branches, let's explore the foundational why. Why not let people sue as many times as they want until they feel they got justice?
It's a fair question.
If someone truly feels wronged, why does the court just shut the door in their face?
Well, we have to consider the practical reality of judicial resources. I mean, courts are funded by taxpayers.
Right.
There are only so many judges and so many hours in a day. The system simply cannot entertain the exact same argument between the exact same people over and over again while, a massive line of other people waits outside the courthouse for their first turn.
It's basically a traffic jam.
Exactly.
Uh-huh.
Furthermore, it's a matter of profound fairness to the defendant. A person should not have to spend their entire life savings defending against the same fabricated grievance year after year.
Right, that'd be harassment.
Exactly. The law demands that once the game is over, the score is final. You do not get a rematch simply because you resent the outcome.
Once the game is over, the score is final. I love that. Let's climb onto that first branch of our tree. Claim preclusion.
Okay, let's do it.
So the Supreme Court laid out the architecture for this in a case called New Hampshire v. Maine. And the general rule is that a final judgment on the merits of an action precludes the parties from successive litigation of an identical claim in a subsequent action.
Which sounds very formal.
Yeah, translate that into a workable reality for us.
Okay, imagine a dispute with your neighbor. Your neighbor backs their heavy truck into your beautiful, expensive wooden fence, destroying it.
Oh, I'd be furious.
Right. So you file a lawsuit, you present your evidence to a judge, and the judge decides against you. you lose the case.
Okay, I lost.
Claim preclusion means you cannot wake up the following morning, draft a new complaint about that exact same broken fence, and file it against your neighbor again.
The courthouse door is locked.
The claim is dead.
Got it. Now, the MBE tests exactly when that door actually locks, because it isn't just magic.
No, it's very precise.
Right. There are 3 strict requirements for claim preclusion to kick in. And to lock these into your mind map, we have a mnemonic.
A very helpful one.
I want you to remember the letters VSS. Think of it as a very strict system. VSS.
So the V stands for a valid final judgment on the merits.
Okay. Valid final merits.
The first S stands for sufficiently identical claims.
And the second S.
The second S stands for sufficiently identical parties.
Okay. VSS. Valid and final on the merits. Sufficiently identical claims. Sufficiently identical parties. Let's interrogate that V.
Okay.
What actually makes a judgment legally valid and final?
Well, a valid judgment requires that the initial court actually possess the constitutional and statutory power to hear the case.
Like they were allowed to be the referee.
Exactly. They must have had personal jurisdiction, meaning legal authority over the specific people involved.
Right.
And they also must have had subject matter jurisdiction, meaning the authority to hear that specific category of dispute.
Like a bankruptcy court can't hear a murder trial.
Exactly. Additionally, the defendant must have been given proper legal notice of the lawsuit and an opportunity to be heard.
So if a totally unauthorized court, let's say, a local traffic court, tries to issue a multi-million-dollar corporate antitrust judgment against you, that judgment is inherently invalid.
Completely invalid. It doesn't block future lawsuits because it wasn't a real authorized game to begin with.
And the same goes if someone sues you in a state you've never visited and you have 0 connections to.
Right. A judgment from a court lacking jurisdiction is void.
Okay, what about the final component? Like, is it final when the judge just bangs the gavel?
Final, in the legal sense, means there is absolutely nothing left for the trial court to do but to mechanically enter the judgment into the record.
Ah, so it's over.
Yes. The presentation of evidence is over, the jury has spoken, or the judge has ruled, and the trial phase is entirely concluded.
Okay, so we have the valid and final pieces. But the real danger zone for the MBE is the last part of that V requirement.
Yes, the on the merits part.
Exactly. Because instinctually, on the merits sounds like the judge and jury sat down, reviewed every piece of evidence, listened to the witnesses, and made like a deeply considered philosophical decision about who was telling the truth.
And that instinct will cause you to fail the exam.
Oh, wow, really?
Yes, because in civil procedure, on the merits is a term of art. It encompasses much more than just a full jury trial.
Okay, explain that.
The most devastating trap here is the could have been raised rule. Claim preclusion blocks not only the exact arguments you actually verbalized in the first lawsuit, but also any claims or defenses that you could have raised during that action but chose not to.
Wait, let's go back to the fence.
Sure.
If I sue my neighbor over the smashed wood or fence, and I intentionally forget to mention that his truck also crushed my prize-winning rose bush during the exact same incident.
Oh, the poor roses.
Right. I'm barred from suing him later for the roses.
You are permanently barred.
Wow.
The legal system forces you to bring your entire arsenal to the battlefield the first time. You cannot hold a secret grievance in your back pocket to weaponize later.
That's intense.
It is. If the damage to the roses was part of the same incident and you had the opportunity to raise it, the law deems it decided.
Hold on, I have to stop you there, because I want to push back on another aspect of on the merits, because it just seems fundamentally broken to me.
Okay, what is it?
The sources state that a default judgment counts as being on the merits.
Yes, it does.
But a default judgment happens when someone gets sued, they don't show up to court, and the plaintiff wins automatically.
Right.
I'm thinking about the reality of people's lives here. What if I get sued, but I'm in a coma, or the mail gets lost, the plaintiff just wins automatically, and the court says the merits of the case were decided?
Right.
But nobody argued a single fact. How is that fair?
Your frustration is completely logical, but you have to separate the concept of fixing a mistake in the original court from the concept of starting a new lawsuit.
Oh, okay. If you are in a coma and miss your court date, the law does provide a remedy. You can go back to that original judge, explain the medical emergency, and ask them to vacate or erase the default judgment.
So you can fix it in the first court.
Exactly. But what you cannot do is ignore that first court entirely, walk into a brand new court across town, and try to start a second lawsuit to counter the first one.
I see.
That is called collateral attack, and claim preclusion absolutely forbids it.
So a default judgment is essentially a forfeit, and a forfeit goes into the record books as a final score.
Assuming you were given proper legal notice and the court had jurisdiction, failing to participate is treated as conceding the match.
Wow. Okay. Are there other procedural shortcuts that count?
Yes. A summary judgment where a judge ends the case early because the facts are undisputed counts. A judgment as a matter of law counts.
Okay, let's examine dismissals then, because cases get thrown out or dropped all the time.
Thank you.
And the exam frequently tests Federal Rule of Civil Procedure 41, which governs dismissals.
Rule 41 is heavily tested. So we need to translate the difference between dropping a case without prejudice versus with prejudice.
Okay, so Rule 41A1B covers voluntary dismissals without prejudice.
Without prejudice.
Right. You, the plaintiff, initiate the lawsuit, but you quickly realize you need, say, 6 more months to gather witness testimony. You file to drop the case without prejudice. You are explicitly reserving your right to bring the lawsuit again later.
So it's just a pause button.
Basically, yes.
The game stops, but the score isn't final. You just have to make sure you unpause and refile before the statute of limitations clock runs out.
Exactly. And the default assumption is that voluntary dismissals are without prejudice unless the paperwork specifically says otherwise.
Okay, but what if it says with prejudice?
A voluntary dismissal with prejudice is the exact opposite. If you dismiss your own case with prejudice, you are making a binding declaration to the court that the dispute is permanently resolved.
Like if you settled out of court.
Exactly. Perhaps you reached a private settlement. That dismissal operates as a full judgment on the merits. It possesses preclusive effect.
Okay, let's weave in a crucial Supreme Court case here, because the MBE uses this specific case to trick students.
Oh, Semtech.
Yes, Semtech International, Inc. v. Lockheed Martin Corp. This case deals with involuntary dismissals in federal court.
Semtech is a masterpiece of procedural complexity.
Break it down for us.
Imagine a federal judge throws your case out. This is an involuntary dismissal under Federal Rule 41B.
Okay.
The rule explicitly states that an involuntary dismissal operates as an adjudication on the merits. So your claim is dead in that federal courthouse. You cannot refile it there.
Makes sense.
But Semtech asks a fascinating question. Does that federal rule automatically force a state court down the street to also lock its doors to you?
Well, yeah. I mean, if the federal judge says game over, you would assume the state judge has to respect that.
Right. You would assume so, but the Supreme Court held that the federal rule governs the federal courthouse. An involuntary dismissal under Rule 41B precludes you from returning to the same federal court.
But the state court.
However, it does not necessarily generate claim preclusion in a state court if the state court's own rules would allow the case to proceed.
Whoa.
The federal door locks, but the state door might remain unlatched depending on state law.
That is a huge trick for the exam. Note that down on your mind maps.
Absolutely.
So what kinds of dismissals are universally agreed to be not on the merits? Like, when do you get an absolute free pass to try again?
The core exceptions occur when the court never possessed the structural power to hear the dispute in the first place.
Okay.
If a judge dismisses your case for a lack of jurisdiction, that is never on the merits.
Got it.
If they dismiss it for improper venue, meaning you filed in the wrong geographic district, that is not on the merits. And if you fail to join an indispensable party under Rule 19, the dismissal is not on the merits.
That makes profound logical sense, actually. A court with no jurisdiction is legally incapable of adjudicating the merits of a dispute.
Right.
They are just a referee telling you that you showed up to the wrong stadium.
That's a perfect way to look at it.
Okay, so we should secure this knowledge before moving forward. We have covered the V in our VSS mnemonic.
Valid. Final judgment on the merits.
Right. We know default judgments and summary judgments count. We know claims you could have raised are swept into the preclusion net. We understand the Semtech distinction regarding federal dismissals, and we know jurisdictional dismissals are never on the merits.
Exactly.
Now, let's explore 2 highly testable special scenarios regarding the merits before we tackle the rest of the VSS mnemonic. The first involves diversity jurisdiction.
Ah, yes. Diversity jurisdiction.
Break that down simply for us.
Okay, so diversity jurisdiction is a constitutional provision allowing federal courts to hear state law claims, like a standard breach of contract or a car accident, if the plaintiff and the defendant are citizens of completely different states.
Okay.
They aren't debating a federal law. The federal court is simply providing a neutral forum, so a local state judge doesn't automatically favor the local citizen.
So the federal judge basically puts on a state judge disguise. They apply state substantive law.
Right. Under the Erie Doctrine, they must apply state substantive law. But how does that impact preclusion?
Right. If a federal court sitting in diversity issues a judgment, and a year later one of the parties tries to bring the exact same claim in a state court, what rules apply?
The Supreme Court ruled that the state court must give the federal judgment the exact same preclusive effect that the local state courts would give it.
Oh, I see.
The federal court essentially borrows the preclusion rules of the state in which it sits.
Another Semtech rule.
Okay.
The second special scenario is family law, governed by a famous case called Eston v. Eston,
Yes.
because marriages ending across state lines create a massive headache for the preclusion doctrine.
Oh, they really do. Eston v. Eston established what we call the divisible divorce doctrine.
Okay, give us an example.
Imagine a married couple living in New York. The relationship deteriorates. One spouse packs their bags, moves across the country to Nevada, establishes residency, and files for divorce in a Nevada state court.
And the spouse back in New York.
The spouse back in New York ignores the lawsuit entirely.
Well, the Nevada court has no personal jurisdiction over the spouse sitting in New York. They have never set foot in Nevada.
Correct. But the Nevada court does have jurisdiction over the marriage status itself because one of the spouses lives there.
Oh, weird.
Right, so the Nevada judge can issue a valid preclusive decree dissolving the marriage. That piece of paper is a final judgment. They are officially divorced. It is known as an ex parte divorce.
So the marriage is dead. But, wait, what about the joint bank accounts? What about the house in New York? What about alimony? Can the spouse in Nevada ask the Nevada judge to award them all the money and then use claim preclusion to block the New York spouse from fighting for it later?
Absolutely not. This is the divisible part of the doctrine. To make a final preclusive decision regarding financial obligations, property rights, or alimony, the adjudicating court must possess personal jurisdiction over both spouses.
Ah, so you can't just steal the money.
Right. You can sever the marital bond unilaterally if you establish residency, but you cannot unilaterally extinguish someone's financial rights without the court having power over them. The divorce is precluded from being relitigated. The division of assets is not.
Okay, that makes perfect sense.
Yeah.
All right, we have thoroughly conquered the V in our VSS mnemonic. Let's transition to the first S.
Sufficiently identical claims.
Right. If I sue someone twice, how does a court actually determine if my second lawsuit is the same claim as the first one?
Federal courts utilize the transactional approach. They do not look merely at the legal theories you are asserting. They look at the underlying real-world transaction or the series of connected transactions that generated the dispute.
Okay, let's expand our earlier car crash hypothetical.
Let's do it.
You are driving down the highway and a delivery truck swerves and crushes your car. You suffer severe whiplash. Your car is totaled, and your expensive laptop in the back seat is destroyed.
Terrible day.
The worst. Now, the entire event, the crash, is a single transaction.
Correct.
So claim preclusion dictates that you cannot slice that single transaction into microscopic pieces. You cannot file a lawsuit for the totaled car on Monday, wait to see if you win, and then file a brand new lawsuit for the whiplash on Tuesday, and a third lawsuit for the destroyed laptop on Wednesday.
The transactional approach forbids that kind of claim splitting. If you bring a lawsuit regarding a transaction, you must bring every conceivable grievance arising from that transaction at the same time.
And this triggers the rule of merging and barring, right?
Yes.
Explain merging and barring.
If you sue the delivery truck company just for the damaged car and you win, any unasserted claims like the whiplash and the laptop automatically merge into your victory. They are absorbed by the final judgment.
So you can't bring them later.
You cannot bring them later. Conversely, if you lose that first lawsuit, the unasserted claims are forever barred. Whether you win or lose, the unlitigated pieces of the transaction vanish permanently.
Do the courts have a specific test to define what actually constitutes a single transaction? Like, how do they measure that?
They weigh several factors. Are the facts related in time, space, origin, or motivation?
Okay.
Do they form a convenient single trial unit? Would presenting all of this evidence to one jury make logical sense? And finally, does treating these events as a single unit align with the parties' normal expectations?
I see.
A single car crash occurring in 5 seconds clearly meets all these criteria.
But what if the delivery truck driver crashes into my car in January,
Yeah.
and then 3 months later I'm walking down the street and that exact same driver purposefully punches me in the face.
Oh my.
I mean, those are completely different transactions, right?
Yes, they share no relation in time, space, or origin. You could sue for the car crash and litigate a completely separate lawsuit for the battery.
Got it. Okay, we are ready for the final S in VSS,
Sufficiently identical parties.
also referred to as a requirement of mutuality. For claim preclusion to operate, for this massive wall to descend and block an entire lawsuit, the exact same claimant must be suing the exact same defendant, occupying the exact same procedural roles.
Strict mutuality is the traditional bedrock of claim preclusion. It must be the exact same human beings or corporate entities.
But of course, the legal texts throw a curveball here.
Naturally.
Mutuality is limited to the original parties or their privies.
Yes. Privity.
Privity sounds like medieval real estate law.
Mm.
If I am in privity with someone, I assume the court treats us as a single legally cloned entity.
That is an accurate conceptualization. A privy is an entity so legally intertwined with you that they essentially step into your shoes.
Like who?
An agent acting under your direct authority is your privy. A legal proxy is your privy. The most common MBE example involves a successor in interest.
Okay, let's build a hypothetical around a successor in interest. Suppose I own a large commercial bakery.
Okay, a bakery.
I sign a massive contract with a flour supplier. The supplier breaches the contract, and I sue them. I lose the lawsuit. The court says the contract was invalid.
Got it.
A year later, I decide to retire. I sell the entire bakery, all its assets, and all its contracts to you. You are my successor in interest.
Okay.
Can you look at that flour supplier and say, well, I wasn't the plaintiff in that first lawsuit. I am a new owner. I'm going to sue you again over that same contract?
I cannot. Because I purchased your business, I am in privity with you. I inherited your assets, but I also inherited your legal defeats.
So claim preclusion blocks you.
It blocks me just as effectively as it blocks you.
But let's clarify a major trap for the exam here. What if multiple, completely unrelated people are harmed by the exact same event?
Okay.
Imagine a city bus loses its brakes and plows into a crowded intersection. The bus hits my car. I sue the City Transit Authority for negligence, and due to a terrible lawyer, I lose. The jury finds the city not negligent. Now, the very next day, my neighbor, who was walking in the crosswalk and also got hit by the exact same bus files, their own lawsuit against the city.
Okay.
Can the city's lawyers point to my lost lawsuit and say, we already proved we weren't negligent regarding this bus crash? Claim preclusion.
They absolutely cannot. Claim preclusion demands strict mutuality. Your neighbor is not you, and your neighbor is not in privity with you.
Right.
They are an independent human being who suffered their own distinct injury. The fact that you lost your case has zero bearing on their right to demand a trial. The parties do not match, so claim preclusion fails.
Okay, let's zoom out and look at what we've built here so far. Visualize the tree for your mind map. We are on branch 1. Claim preclusion, also known as res judicata. It is the giant wall blocking a repeated lawsuit.
Yes.
Our mnemonic is VSS.
V is for valid, final judgment on the merits. Remember, default judgments count. Jurisdictional dismissals do not.
S is for sufficiently identical claims. Remember the transactional approach. You cannot split up the car crash.
And the last S is for sufficiently identical parties. Strict mutuality or privity is required.
If you can navigate VSS and recall the Semtech and Eston exceptions, you possess the analytical tools to dissect any claim preclusion fact pattern.
Absolutely. You are ready.
Okay, so we have established how claim preclusion acts as a giant wall to block an entire lawsuit.
Yeah.
But let's twist the scenario.
Okay.
What if we have a completely new lawsuit?
Mm-hmm.
Different claims, maybe different parties, so VSS fails completely.
Okay.
But inside this brand new lawsuit, the parties are arguing fiercely over one highly specific fact, a fact that a judge or jury already conclusively decided in a previous case. Do we really force the judicial system to spend weeks listening to evidence about that one specific fact all over again?
The system refuses to do that, and this requires us to climb branch 2 of our tree. Issue preclusion, legally termed collateral estoppel.
Right. Issue preclusion stops parties from relitigating specific isolated issues of fact or law that were already conclusively determined in a prior action.
Exactly.
Let's create a visual analogy to distinguish this from our first branch.
I love analogies.
Claim preclusion branch 1 is like being permanently banned from a restaurant. You cannot walk through the front door. You are entirely excluded.
The whole claim is barred.
Exactly. But issue preclusion branch 2 is fundamentally different. You are allowed inside the restaurant. You can sit at a table. You can order a steak or a salad.
Okay.
However, in a previous lawsuit, a judge conclusively determined that you have a severe peanut allergy. Therefore, you are banned from ordering the peanut soup. You can participate in the restaurant experience, but you are absolutely precluded from relitigating the specific issue of your peanut allergy. That one fact is locked in a vault.
The restaurant analogy perfectly illustrates the surgical nature of issue preclusion. It doesn't destroy the entire case, it simply removes specific puzzle pieces from the board.
Okay, so we need a new mnemonic to secure branch 2 to our mind map. To remember the requirements for issue preclusion, think of a vault keeping a fact locked away. The mnemonic is SAFE, S-A-F-E.
Safe. Let us unpack the safe mnemonic.
Go for it.
S stands for the same issue. A stands for actually litigated.
Okay. S-A.
S stands for a final valid judgment, and E stands for essential to the judgment.
Same. Actually litigated, final, essential. We will examine the S first. Same issue.
So, for a court to lock a fact in a vault, the issue sought to be precluded must be identical in every meaningful respect to the issue decided in the first case.
Identical.
We look to a Supreme Court tax case called Commissioner v. Sonnen. The court emphasized that the facts surrounding the issue, AA, the applicable legal framework, must be perfectly identical.
Oh, wow.
Yes. If the legislature has changed the underlying law between the first lawsuit and the second, or if the factual context has meaningfully shifted, it is no longer the same issue. The vault remains open.
The matching must be absolutely precise. Okay, now let's tackle the A in SAFE. Actually litigated.
This is a big one?
I want to highlight this because my brain is flashing a massive warning sign.
What's the warning?
In claim preclusion, we spent significant time establishing that default judgments, where someone simply fails to show up, DO, count as a decision on the merits. Does a default judgment count as actually litigated for issue preclusion?
It absolutely does not. This is one of the most frequently tested distinctions on the bar exam. Think back to your restaurant analogy. If you fail to show up for your dinner reservation, the manager might ban you for being flaky.
Right.
But your failure to show up did not prove to the manager that you have a peanut allergy. They never saw you eat a peanut.
That's completely true.
In the legal context, for an issue to be precluded, the parties must have genuinely engaged in combat over it. Evidence must have been submitted, legal arguments must have been articulated, and the judge or jury must have actively weighed the conflicting information to reach a conclusion.
And a default judgment has none of that.
A default judgment involves zero combat. Nothing was actually litigated.
So if I default on a lawsuit alleging I breached a contract, claim preclusion stops me from suing later to say the contract was valid. But the plaintiff cannot take that default judgment, walk into a second unrelated lawsuit and say, a judge already proved he's a contract breacher, so we don't have to argue about his character here. The specific issue of my conduct wasn't fought over.
Precisely. Now, what if the parties fight viciously over a procedural issue rather than a substantive one?
Does that count?
In Stoll v. Gottlieb, the Supreme Court addressed whether a fight over jurisdiction counts. The court ruled that if parties actively litigate whether the court has jurisdiction and the judge issues a ruling stating they do, that specific procedural issue is locked.
Oh.
You cannot walk into a second court and attempt to relitigate the first court's jurisdiction. You fought over it, you lost, it is actually litigated.
Moving to the F in SAFE. Final, valid judgment. I assume this functions exactly the same as the V in our claim preclusion mnemonic.
The mechanics are identical. The court making the initial determination must have possessed legal authority, and the decision must be fully resolved with nothing left for the trial court to do.
That brings us to the E in SAFE, essential to the judgment. A fact was decided, but how do we know if it was actually essential?
Judges frequently write lengthy philosophical opinions. Occasionally, they include supplementary observations or hypothetical musings that do not directly impact the final outcome.
Like little side notes.
Exactly. The legal term for these side comments is dicta. Dicta is entirely immune from issue preclusion.
Good to know.
To be locked in the vault, the fact must have been an unavoidable, structurally necessary puzzle piece required to build the final verdict. If you could remove that specific factual finding from the judge's opinion, and the ultimate winner of the lawsuit would remain exactly the same, then the fact was not essential.
Okay, let's create a hypothetical to make that concrete. A judge issues a ruling stating the defendant is guilty of running the red light and causing the crash. Furthermore, the defendant was wearing an incredibly ugly green shirt.
Okay.
The finding that the light was red was structurally essential to proving negligence. The finding about the ugly green shirt is pure dicta. The plaintiff cannot take that judgment to a subsequent defamation trial and use issue preclusion to legally prove the shirt was definitively ugly.
The green shirt was not essential to the judgment.
Hey.
Exactly. You have mastered the safe mnemonic. Same, actually litigated, final, essential.
But wait, we have built this rule that says only the exact same people can use these judgments. We stress mutuality and claim preclusion. What happens in issue preclusion? Do we still need strict mutuality?
It's a great question.
Because what if there's a massive public disaster like a pharmaceutical company releasing a toxic drug and 500 different patients are suing the same company? Do we really make the courts prove the chemical is toxic 500 separate times just because the plaintiffs are different?
This is where issue preclusion evolves into an incredibly potent weapon. The modern rule heavily modifies the mutuality requirement.
Oh, really?
Yes. The foundational principle is that the party against whom preclusion is being asserted, the one getting blocked, must have been a party in the original case. They must have had their fair day in court to defend themselves.
Right.
However, the person wielding the preclusion, the one using the past judgment to their advantage, does not necessarily need to have been involved in the first lawsuit.
Wait, really? This sounds like offensive collateral estoppel.
Exactly. The Supreme Court endorsed this in a landmark case called Park Lane Hosiery v. Shore.
Okay, what happened in Park Lane?
The Securities and Exchange Commission sued Park Lane Hosiery for issuing false proxy statements. The SEC and the corporation fought a massive legal battle. The judge ruled that the statements were indeed materially false. Park Lane lost.
No.
Following that government victory, a group of private shareholders filed their own civil lawsuit against Park Lane to recover financial damages.
So the private shareholders were entirely new plaintiffs. They were not involved in the SEC lawsuit.
Correct. The shareholders walked into court, pointed to the SEC judgment, and argued, "We shouldn't have to spend a month proving these proxy statements were false." Park Lane already fully litigated that exact issue against the SEC, and they lost. We want to use that judgment offensively as a sword.
And what did the court say?
The Supreme Court agreed. A new plaintiff can use a prior judgment offensively against a defendant who already fought and lost on that specific issue.
Let's push that further, because I can imagine defense attorneys screaming about unfairness here. A corporation might defend a minor low-stakes lawsuit, lose, and suddenly face an avalanche of new plaintiffs, wielding that minor loss as a lethal weapon in billion-dollar class actions.
The Supreme Court recognized that precise danger. While offensive collateral estoppel is permitted, trial judges are granted broad equitable discretion to forbid it if its application would be fundamentally unfair to the defendant.
How does a judge calculate unfairness?
They look for two primary abuses. First, they look for the wait-and-see plaintiff.
The wait and see.
If you easily could have joined the first lawsuit, but you intentionally hid in the bushes to see if the first plaintiff would win so you could catch a free ride, the judge will deny you the sword.
Oh, wow. Yeah, that makes sense.
Second, they examine the stakes of the initial litigation. If the first lawsuit was over a $500 dispute in small claims court, the corporation likely didn't hire their best lawyers or aggressively litigate every detail.
Right. Why spend $1 million to fight over $500?
Exactly. If a new plaintiff then tries to use that $500 loss to guarantee victory in a $50 million lawsuit, it violates basic principles of fairness. The defendant lacked the incentive to litigate vigorously in the first round.
That balances efficiency with due process. Now, the sources detail 6 highly specific exceptions where someone who was never a party in the first case can actually have a judgment used against them.
Yes.
This comes from Taylor v. Sturgill. Instead of just listing them out like a textbook, let's imagine a scenario where a massive airplane manufacturer is being sued over defective wing design, and we will see how non-parties get bound by the results.
A complex corporate narrative is the best way to understand the Taylor exceptions.
Okay, what's exception 1?
Exception 1 involves explicit agreement. Imagine an airline company signs a contract with the manufacturer stating, "We agree to be legally bound by whatever verdict is reached in the ongoing Federal Aviation Administration investigation." They have explicitly consented to non-party preclusion.
Makes sense. Exception 2 involves pre-existing substantive legal relationships.
Consider a Baylor-Bailey dynamic.
Like renting a car.
Exactly, or renting a private jet from an owner. You are the Bailey, you crash the jet, sue the manufacturer claiming the wing was defective, and you lose. The court finds the wing was perfectly safe.
And the owner.
The owner of the jet, who is never in the courtroom, is bound by your loss because of their substantive legal relationship to the property you are operating. They cannot file a second suit claiming the wing was defective.
Okay, exception 3 is adequate representation. This is the class action scenario, right?
Exactly. A class action lawyer represents 10,000 passengers. Only one lead plaintiff actually sits in the courtroom. If the lead plaintiff loses, all 10,000 passengers are precluded from suing individually later because their interests were adequately represented by a party with identical incentives.
Wow, okay. Exception 4, assume control. I imagine like a corporate puppet master.
Suppose a massive parent conglomerate forces its tiny subsidiary company to sue the airplane manufacturer. The parent company's name is nowhere on the legal paperwork.
But behind closed doors.
But behind closed doors, the parent company is paying the legal fees, hiring the experts, and dictating the trial strategy. If the subsidiary loses, the parent company is bound by the judgment because they effectively assumed control of the litigation.
Exception 5 is the proxy exception.
You lose your lawsuit against the manufacturer. Furious, you instruct your personal assistant to file the exact same lawsuit under their own name, acting entirely as your agent. The court recognizes the assistant is merely a proxy attempting to circumvent preclusion, and the suit is barred.
And exception 6, special statutory schemes.
Congress occasionally passes highly specialized legislation, such as certain bankruptcy procedures or complex environmental regulations, that explicitly permit successive litigation to be blocked across broad classes of people, provided the statute incorporates strict due process safeguards.
The Taylor exceptions cover almost every loophole. But there is one final, narrow exception mentioned from a case called Richards v. Jefferson County. Virtual representation.
Yes. The Richards court severely restricted this concept. You cannot bind a non-party simply by arguing that someone else in a prior case had similar interests and virtually represented them.
Ori.
To bind a non-party through representation, there must have been special procedural safeguards designed to protect them, or the non-party must have received explicit legal notice that the first suit was being prosecuted in a representative capacity on their behalf. Without notice or procedural protection, virtual representation fails.
Okay, we have mapped the trunk and both major branches. But we need to apply these mechanics to two special arenas that the bar exam absolutely loves to exploit. First, equity court.
Equity courts are unique.
Because sometimes courts don't deal with financial damages. They exercise equitable power to force someone to do something, or they operate in specialized arenas like bankruptcy. Does our safe mnemonic still apply when we leave traditional courts of law?
It applies with equal force. The Supreme Court in Katchen v. Landy confirmed that equitable findings are fully capable of generating issue preclusion.
Okay.
If a bankruptcy judge, operating without a jury, actively litigates and decides a core factual dispute necessary to administer an estate, that factual determination is locked.
Yeah.
It satisfies the safe requirements and cannot be relitigated in a subsequent civil trial.
Now for the grand finale, the most treacherous trap of the entire topic. The criminal versus civil crossover.
Oh yes, this is a massive trap.
Let's construct a scenario. Two individuals get into a violent altercation at a bar. The police arrive and arrest one of them. The state prosecutes the defendant in criminal court for the crime of aggravated assault.
Okay, criminal trial first.
Following the conclusion of the criminal trial, the victim of the fight files a lawsuit in civil court against the defendant, seeking financial compensation for their hospital bills under the tort of battery.
A classic crossover.
How does preclusion operate across the criminal-civil divide? Let's take scenario A. The prosecution wins the criminal trial. The jury finds the defendant guilty.
This hinges entirely on the burden of proof. In a criminal trial, the state must prove guilt beyond a reasonable doubt. This is the highest, most demanding evidentiary standard in the American legal system.
Right.
If the criminal jury determines beyond a reasonable doubt that the defendant struck the victim, that specific factual issue, the physical act of striking IS, precluded in the subsequent civil trial.
Because in civil court, the burden of proof is much lower. The victim only has to prove it is more likely than not, which is a preponderance of the evidence.
Exactly.
So if the state proved the punch happened at the impossibly hard criminal level, it is automatically proven at the much easier civil level. The civil jury must accept the punch as an absolute, undeniable fact. The defendant can only argue about how much the medical bills cost.
Your analysis is flawless, but the exam trap lies in scenario B.
What if the defendant wins the criminal trial? The jury delivers a verdict of not guilty. They are acquitted.
Yes.
See, if they are acquitted, they are found not guilty of the assault.
Okay.
Common sense suggests they should be immune from the civil lawsuit. Why would a civil court force them to defend themselves again over the exact same bar fight?
An acquittal in criminal court generates zero issue preclusion against the civil plaintiff.
Wait, zero.
The victim can proceed with the lawsuit, and the victim can absolutely win financial damages despite the criminal acquittal.
Okay, explain the mechanics behind that, because it feels completely contradictory to someone outside the legal profession.
There are two intersecting mechanical reasons. First, reverse the logic regarding the burden of proof. An acquittal does not mean the jury believed the defendant was innocent.
It doesn't.
An acquittal simply means the prosecution failed to meet the incredibly high bar of beyond a reasonable doubt. The jury might be 80% sure the defendant threw the punch, but that 20% doubt forces an acquittal.
Oh.
However, in the civil trial, the victim only needs to prove they are 51% sure, more likely than not. A defendant can easily fail the criminal test, but simultaneously fail to defend against the civil test.
That makes perfect sense. It's like failing to qualify for the Olympic weightlifting team, but still being strong enough to win a high school arm wrestling match. The standards are entirely different.
That is an excellent analogy. But the second reason is even more fundamental, and it brings us back to the bedrock requirements of mutuality and due process we discussed regarding issue preclusion. Who was the plaintiff in the criminal trial?
The state. The government prosecutor.
Correct. And who is the plaintiff in the civil trial?
The victim. The person who suffered the broken jaw.
Exactly. The civil plaintiff was not a party to the criminal case. The victim did not hire the prosecutor, they did not direct the trial strategy, and they had no control over what evidence was presented.
Right.
Remember our ironclad rule. You can only use issue preclusion against someone who actually had a full and fair opportunity to litigate in the first round. Because the victim was not a party to the criminal trial, it violates the Constitution to bind them to the prosecution's failure.
The victim gets their own day in court? They aren't blocked because they were never in the arena?
Precisely.
Wow, okay. We have reached the summit of the mountain. Let's assemble our entire mind map one final time to cement this for our ESL listeners and everyone preparing for the bar.
Let us construct the tree.
The massive trunk of our tree is the preclusion doctrine. Its entire existence is justified by the need for judicial efficiency and fairness to defendants. It stops endless, repetitive litigation.
And then we have the branches.
Branch 1 is claim preclusion, or res judicata. It is the giant wall that blocks an entire lawsuit from proceeding.
And your mnemonic.
To navigate this branch, use the mnemonic VSS, valid, final judgment on the merits, sufficiently identical claims, sufficiently identical parties.
And remember the traps. Default judgments are considered on the merits. You cannot divide a single transaction into multiple lawsuits. And under SEMTEC, an involuntary dismissal in federal court locks the federal door, but might leave the state door wide open.
Okay, and branch 2.
Branch 2 is issue preclusion, or collateral estoppel. It doesn't block the whole lawsuit. It surgically removes a specific fact from debate.
Navigate this branch with a mnemonic safe. Same issue. Actually litigated. Final judgment. Essential to the judgment.
And the traps here. Default judgments do not count because nothing was actually fought over. Dicta is not essential. You do not always need identical parties because a new plaintiff can use offensive collateral estoppel as a sword, provided it doesn't violate fundamental fairness. And finally, a criminal acquittal never blocks a civil lawsuit.
If you can visualize that complete architecture and recall those two mnemonics, you will dissect these exam questions with absolute precision.
We really will.
But let's push beyond the exam material for a moment. We've discussed rules formulated in the mid-20th century. How does this doctrine survive the technological revolution?
It is a profound philosophical dilemma. The entire preclusion doctrine prioritizes finality. But consider the proliferation of digital evidence, deepfakes, and artificial intelligence.
Oh, wow.
What happens if a final preclusive judgment is entered today based on video evidence that was actually litigated and deemed authentic by a jury?
Yeah.
What if, 5 years from now, a revolutionary AI analysis tool proves with absolute mathematical certainty that the video was a sophisticated forgery and the court was completely wrong about the core essential fact?
That's terrifying.
At what point does humanity's intrinsic need for objective truth override the judicial system's mechanical need for finality?
That is the ultimate tension. If we refuse to reopen the vault, the preclusion doctrine stops being a shield for fairness and transforms into a concrete tomb that locks in a technological mistake forever.
Yeah.
Finality versus truth.
It is a conflict the courts will inevitably have to resolve in the coming decades.
To you, our listener, thank you for joining us on this deep dive. Review your mental mind maps. Sketch the tree on a piece of paper. Practice reciting VSS and SAFE until they are automatic. You understand the architecture, you recognize the traps, and you are prepared to conquer this material. Until next time.